Rigathi Gachagua's impeachment case is a defining moment in our country, both politically and legally. I have seen many quarters reporting that Rigathi has suffered a blow because for the fifth time, I think, the High Court has declined to stop Parliament from debating this case. The first time Rigathi Gachagua went to the High Court, he wanted the court to stop tabling of that debate. He wanted the courts to stop Mwende Mitusi from tabling that debate, even from reading it, and the courts declined. The second time he went to the High Court again, he wanted the courts to bar Parliament from debating it and to bar Parliament from conducting public participation on his impeachment. The courts declined. Then he went again to the court when the matter was dealt with at the National Assembly and they voted to impeach him. And therefore, attention shifted to the Senate. And Rigathi Gachagua went to the High Court again, and he wanted to bar the Senate from debating this impeachment question because he wanted this to go direct to Madam Martha Koome, and the courts declined that request.
If a state organ fails to abide by any of the values and principles in the Constitution, the court exercises its mandate under Article 165 sub-Article 3 will come in and investigate whether anything said to have been done under the authority of the Constitution is inconsistent with or in contravention of the Constitution. It was in this respect the Supreme Court stated in a matter case that it would be reluctant to question parliamentary procedures as long as they did not breach the Constitution, and that the mandate of the court is restricted to the doctrine of separation of powers, to deciding on matters of individual rights and fundamental freedom. The Supreme Court then stated that in the exercise of their wide political powers, both the county, read National Assembly, and the Senate cannot act outside the confines of the Constitution and the law. For to do so would invariably invite the court's intervention. End of quote. Article 2 sub-Article 4 of our Constitution is not only the hope but also the promise of our Constitution that we must abide by the constitutional dictates, for any act or omission in contravention of the Constitution is invalid. In that respect, I conclude this matter, and this is what I say. Having considered the application and argument by parties, the Constitution and the President, the prayer for grant of conservatory order is declined. However, in view of the issues raised in this petition, which also appear to relate to those in petition E522 of 2024, which has been certified for purpose of appointing a bench of an even number of judges to hear, I certify this petition as raising substantial questions of law and of public interest in terms of Article 165 sub-Article 4 of the Constitution. This file is to be placed before the Honorable Chief Justice to consider appointing an uneven number of judges to hear this petition. Given the close proximity of the issues in this petition and those in petition E522, the Honorable Chief Justice may consider whether this petition may be heard by the same bench appointed to hear petition E522. I make no orders on course. Thank you.
Now, the reason why I want to respectfully disagree with those who are saying that Rigathi has suffered a blow is because the courts have granted Rigathi Gachagua another prayer. In the previous 2 days, through his senior counsel, Paul Mwite, Rigathi had argued that he wanted this matter to be referred to the Chief Justice, Martha Koome, to constitute a bench to listen to this matter because he felt that the matter was so weighty that it went beyond listening by just one judge. And when it was referred to the Chief Justice constituted a bench of 3 judges. So he was granted those prayers. But on the prayers of trying to bar or stop the parliament, both the National Assembly and Senate, to listen to this matter, the courts have declined. Now, in this video, ladies and gentlemen, I want to explain to you why I feel that Rigathi has not suffered a blow, or rather why the courts are declining such a request, because I think it is to the benefit of Rigathi Gachagua. Because if the court would rule that the Senate or the National Assembly should not debate this matter, it would be to the detriment of Rigathi Gachagua. And why am I saying so? Before we delve into this, kindly subscribe to our channel if you are visiting us for the first time. Click the notification bell. You can also help us share videos, and please give this video likes. It goes a long way in promoting our channel and promoting our videos. Thank you very much for the returning subscribers and all our supporters. Ladies and gentlemen, for those who have been following this channel, I've maintained that there are three arms of the government that must work independently. No arm of the government should be seen as interfering with the functions of another. And therefore, if the courts would even attempt or be seen as if they are interfering with the functions of parliament, of the National Assembly or the Senate, this will be in bad faith. And therefore, the courts are declining such requests so that they are not seen as if they want to interfere with the legislative arm of the government. It is the role of parliament, the role of the National Assembly and the Senate to impeach, or rather look into the conduct of state officers. And therefore, that role must be left to them. As Judge Chachagwita was saying there, the case must be left to go to the fullest, so that if there is any party that is aggrieved, then they will now proceed to the courts to seek for legal interpretation and legal redress. And that's why I feel that it is good for the court to decline such, because it will work for Rigathi Gachagua. Parliament will not feel like if there is interference. The courts also are trying to avoid being accused of being biased and taking side of, in this case. If you witness what happened in the National Assembly, in the courts of the public opinions, people are judging that Parliament was captured by the political masters, William Ruto, Rigathi Gachagua, and maybe Kalonzo Musyoka, because they voted in accordance to the feeling of their masters. So Parliament wants to be seen to be very non-partisan in this matter. They don't want to be seen as if they are supporting Rigathi Gachagua so much, because in the event that they rule, for example, the three-judge bench rules that Rigathi Gachagua is innocent, then people will not start saying that, we knew you had banned Parliament from discussing this. So they don't want to be seen as if they are partisan. They want to be neutral. That is why they must be there as neutral arbiter, not taking side. Remember, the Speaker of the National Assembly, Moses Wetangula, and his deputy, Gladys Shulei, had taken sides talking outside Parliament. They had said and vowed that they will deal with Rigathi Gachagua. So the courts do not want to be seen as if they are also players, yet they are supposed to be referees. Number three, both parties must be satisfied. When the final verdict comes, then both Rigathi and the National Assembly must be satisfied, because Rigathi was granted his prayers for the constitution of the three-judge bench, but he was also denied the prayer to bar or to gag Parliament from debating this. So Parliament will be very satisfied, because the courts have given them their leeway, the courts have given them their rights and freedom, because the freedom or the rights of the functions of the National Assembly, of the Senate, of the Judicial, and of the Executive are donated by the people. All those rights are donated by the people. So the courts want both Gachagua and the National Assembly or the Senate to be satisfied once the verdict comes out. Because finally, even if Senate is going to impeach Gachagua, Gachagua is going to appeal even at the highest court. Number three, the courts, or rather Madam Martha Koome, wants to exercise independence of these institutions. And in a way, She's sending a coded message to the executive arm of the government, headed by William Samoei Ruto. Remember, the executive arm of the government has been accused of interference. The executive has captured the National Assembly, the Senate. In fact, it goes beyond. All these independent institutions like the office of the DPP, the DCI, and all that are under the pocket of the executive arm of the government. So Madam Martha Koome is simply sending a coded message that we want to respect the independence of these three arms of the government, of each independent institutions, so that no one will say that we interfered, we aid or we barred them. And they are also telling the executive, please respect the other institutions. It is a coded message. That is how to deal with errant independent institutions or arm of the government. And I think the courts are also trying to avoid any rift among the three arms of the government. There should be a smooth and coordinated running among the executive, legislative, and the executive arm of the government. And I think this has been achieved. For those who are saying that I don't know, Rigathi Gachagua has suffered blockade, I could be wrong, but I tend to disagree. And even the lawyers who went to court to seek for these prayers understand very well that the court or the judiciary cannot interfere with the functions of the legislators. And I think it is for the good of Rigathi Gachagua. By the end of it all, wananchi are looking at what is happening and all the parties shall be satisfied. As to whether the executive has captured the judiciary, because some people feel that there's not going to be any justice because William Ruto seems to have captured the judiciary, I don't know. We wait and see. As to whether legislators, the senators are going to vote independently or they are going to follow their master's orders, we wait and see. But it's going to be a very interesting legal battle, cross-examination and proof and evidence, because the burden of proof lies with those who accuse Rigathi Gachagua.